Welcome to This Week in Education Law School Administrator's Guide, episode number 18. The case I introduce this week is about how school administrators messed up the process of terminating a teacher's contract. In this case, a teacher had been a full-time Spanish language teacher in a high school in Sibley Ocheyedan Community School District in the state of Iowa since 2001. On April 25, 2019, the teacher was informed by her school principal and superintendent that she would be placed on an intensive assistant program to address deficiency in meeting 6 of the 8 Iowa teaching standards. The school principal read to the teacher from a plan of assistant document, which included a bulleted list of 14 requirements for the teacher to meet. The document also included signature lines for both the school principal and the teacher to sign. Under the signature lines, there was a statement. Signature of the teacher does not indicate that the teacher agrees with the content of the review, only that they have received a copy. The teacher refused to sign her name. Regardless, she received a copy of the document and was told that she'd be responsible for carrying out the plan starting immediately. The document stated that the teacher would begin working on improving her teaching performance in spring 2019 and would meet and discuss during the 2019 to 2020 academic year. Satisfactory progress must be achieved to maintain the teacher's employment for 2020 and beyond. In summer 2019, the superintendent left the school district and was replaced by the new superintendent. At the end of the summer on August 21st, the school principal and the new superintendent met with the teacher to discuss the intensive assistance program. The intensive assistance program provides organizational support and technical assistance to teachers, other than beginning teachers, for the remediation of identified teaching and classroom management concerns for a period not to exceed 12 months. During the meeting, the school principal read the same plan of assistance document presented to the teacher 4 months ago on April 25th. In the August meeting, the teacher interrupted multiple times. Different people had different interpretations of the same fact. In the view of the school principal and the superintendent, the teacher disparaged or challenged various components of the plan. But in the teacher's view, she was seeking clarification or explanation about parts of the plan. Regardless of different interpretations, the teacher's interruptions agitated the new superintendent, who at one point saying, "Do I need to ask for your resignation now, or can this meeting continue?" The teacher persisted, and the superintendent informed her that the meeting was over and told her to get out of his office. About 2 months later, on October 11, 2019, the teacher tried to initiate a conversation with the school principal in the supply room about the plan and noted that her evaluation was to happen within the next few weeks. The teacher felt the school principal's response lacking in substance, so she went to the superintendent's office to try to speak to him. The superintendent responded by asking the teacher to meet back at his office at 3:30 p.m. When the teacher returned at 3:30, the superintendent directed her to the boardroom where the school principal was waiting. In the boardroom, the superintendent provided the teacher with a written separation agreement. Under the proposed agreement, the teacher would resign from her teaching position with the school district, and in exchange, the district would continue to pay her salary and provide insurance through the end of the school year. The teacher did not sign the agreement. The school principal testified that the superintendent told the teacher, "One way or another, you won't be here Monday," and that if the teacher didn't sign the agreement that day, she'd be placed on administrative leave until the offer's expiration date in 21 days. But the teacher testified that She did not recall being told that she'd be placed on administrative leave if she didn't sign the agreement. The teacher reported for work as usual on the following Monday, October 14th, fearing that if she didn't appear for work, it would be held against her. The superintendent told the school principal to contact the county sheriff's office to have the teacher removed from the school. 1 month later, on November 13th, the school district served the teacher with the notice of her upcoming termination proceeding, at which the school board would consider the superintendent's recommendation to terminate the teacher's teaching contract based on the following reasons. First, an intensive assistant program was provided to you and you refused to comply with the program with regard to grading. Second, failed to teaching appropriate to grade level. Third, failed to meet teaching standard 8. Fourth, students in Spanish 2 have not received appropriate instruction. The school board accepted the superintendent's recommendation and terminated the teacher's contract in January 2020. The teacher filed a lawsuit against the school district, claiming that the school district fired her when she was still completing the intensive assistant program described in Iowa Code Chapter 284. Under the school district's policy implementing Chapter 284, teachers who are required to participate in an intensive assistant program have at minimum 6 months and at most 12 months to complete the program. If following the teacher's participation in the program, the teacher has not successfully completed the program or continues to fail in meeting performance standards, then the school district has the power, among other options, to immediately terminate the teacher's employment. But in this case, the school district fired the teacher before she completed her intensive assistance program. The teacher claimed that she was denied her contractual and statutory right to complete the intensive assistant program. The school district argued that under the Iowa Code, the school district possessed the power to terminate the teacher during the contract year for just cause, such as performance deficiencies, insubordination, assaulting a student, embezzling funds, and falsifying student grades, regardless of any ongoing intensive assistance program. The teacher appealed the school board's termination decision to the district court, which affirmed the school board's decision. The teacher appealed. The Court of Appeals reversed the district court's ruling and the school board's termination decision. The school board sought further review, which the Supreme Court of Iowa granted. The court reasoned that the beginning clause that introduced Iowa Code states following a teacher's participation in an intensive assistance program. That language indicates that the school district's power to dispense with a teacher failing to meet the teaching standards arises only after the teacher is given an opportunity to participate in the intensive assistance program. The court held that the school district violated the law when it terminated the teacher's contract for the same performance reasons addressed in her ongoing intensive assistance program before the teacher had been given the requisite period to participate in the program. The school district failed to provide sufficient evidence of just cause that justifies an immediate termination because other just cause was not stated in the superintendent's notice of termination. In this video, I discuss a case of how a school district violated a teacher's contractual and statutory right to complete the intensive assistant program when the district terminated the teacher before she was afforded the time to complete the intensive assistance program. To be clear, school district can fire teachers immediately for just cause, such as performance deficiencies, unprofessional conduct, or conduct unbecoming, criminal behavior, drug-related conduct, insubordination, changing students' transcripts, and having sexual relationship with a student. But in this case, the teacher who failed to meet the state standards was required by the law in Iowa to complete the intensive assistance program before she could be fired by the district. When you plan to terminate a teacher's employment contract, you'd better check your state law and procedures and follow them. I hope the case introduced today is helpful for your daily work. I will see you next week in This Week in Education Law, School Administrator's Guide.